his remorse. Oceans you fill for yourself alone. Flurry Samson that now dethroned. So pity your river, not a drop for him. Your high ground's a shadowy west end. Samson, not back with your selfish woes. No room for the tears, only you.
Hey guys, it is Mo, and there is a motion commotion. Sarah Boone's lawyer has, filed all the motions, so I am here to walk you through them, and, well, there's a lot, so let's get into it. The first one is a motion for return of property, or in the alternative, a motion for an independent exam by the defense. Yes, I'm sure the CIA, MI5, and Mossad got together to frame Sarah Boone. Comes now for the defendant, Sarah Boone, by and through counsel James S. Owens, pursuant to Florida Rules of Criminal Procedure, Rule 3.220, and files the instant motion stating the support thereof the following. 1. Defendant Sarah Boone is charged with the above styled and number case in a count of information with second-degree murder, which is punishable by up to life. 2, the above styled case number is currently set for jury selection on October 7th, 2024, before the Honorable Judge Michael Kranick. And I love angry eyebrows judge. I really do. He has the eyebrows of justice. He has the brows of hell no. And I like it because both of them come down in this little V like Angry Birds when Sarah's like, we need to embiggen the timeline. And he's like, did you not read my as per our previous email, I will not be extending the time. Do I need to write it in Crown? I love it. He has that face. Or at least I pretend that's what his inner monologue is. 3, Miss Boone was arrested February 25th, 2020 after giving a statement to law enforcement. At that time, she purportedly consented for her cell phone to be searched, and it was seized. It was purported video evidence from Miss Boone's cell phone that led to the filing of the instant charges. 4, since February 25th, 2020, the defendant has been continuously in custody in the Orange County Jail without bond, and neither she nor her attorneys have had the opportunity to see and review her cell phone or have it analyzed by an independent person or the defense team. Maybe that's because she couldn't keep a lawyer because she's a massive see you next Tuesday. I mean, I could be wrong, but I'm going to call balls and strikes as I see them, and that's a wiffle ball strike. She is just a terrible human to have to human with. 5, counsel on behalf of Miss Boone have timely filed a notice of intent to use battered spouse defense. I have already said my piece about that, but every time I see it, it really just burns my biscuits, y'all. 6, much of the evidence in support of Miss Boone's defense, including but not necessarily limited to battered spouse, is contained in her cell phone, including documentation to support this defense. The information contained in her cell phone includes, but is not limited to, text, photographs, and additionally, perhaps essential to her defense. Sorry, we're getting a Thor sighting because, he's like, why not? I'm only 40 pounds of cat. I would like to, just completely derail your stream. Thank you so much. But potential evidence such as witnesses' names and contact information. Okay, no, you're going down, sir. We have talked about mommy's desk not being a plaything. I will probably be getting a cat tree in here, but I have plans to move this office around and make it more functional. So sorry for the tangenting, guys. I really am trying to stay on focus, allegedly. Now, 7, the Office of the State Attorney and their agents have this evidence, i.e. said cell phone, in their exclusive possession for their exclusive use, examination, analysis since February 25th, 2020, 4.5 years. Sir, they haven't been hiding it just to screw with Sarah. I know this is a weird concept, but she could never keep a lawyer to the point where they could get to actually look at discovery. 8, presumably the state's attorney's office and their vast resources, financial, technological, and investigative, etc., have had sufficient time to review and analyze all the data from said phone and to transfer and preserve all needed punitive evidence without the necessity of maintaining the physical possession of the cell phone. Ma'am, you are not getting your cell phone back. Stop it. Also, it's the thing that, sealed your fate and cooked your goose. Do you seriously want this cursed thing back? I mean, again, you tracked your crime. We have talked about this in the Church of Mo. There are several rules for criming, and it's don't write it down, don't Snapchat it, don't videotape it, and never tell anyone. I don't know why these rules are so hard to follow. I am glad that most criminals do not follow them, though, so we can catch them and put them in prison. Yes, we can. Now, 9, the defendant respectfully moves the court to order directing the immediate release of Ms. Boone's personal cell phone to her attorney or a member of the defense team acting on her behalf. 10, should the court not grant release of the cell phone to defense counsel, counsel would move in the alternative to examine said cell phone or have a defense expert examine the phone to retrieve the much needed evidence to support her defense. 11, without this evidence, Ms. Boone will be deprived of her rights under Florida law as well as federal constitutional mandates. 12, under Florida Rules of Criminal Procedure, Rule 3.220, quote, the prosecutor shall disclose to the defendant and permit the defendant to, quote, inspect, copy, test, photograph any tangible objects that were obtained from the defendant. See said rule. 13, should the defendant, counsel, and their representatives not be allowed to obtain Ms. Boone's cell phone or at the minimal attain a favorable evidence, not only will procedural state rules be violated, but result in a violation under Brady versus Maryland. And Brady versus Maryland is basically a caveat large one, and take with a grain of salt or all of the ramen noodle seasoning packets you have. But a Brady violation is when a prosecutor knowingly withholds exculpatory evidence from the defense. So you can think of it as, say they have a timestamp that shows that the person is completely in another county on the Cellbrite download, but they edit that out or they don't give that page over. That would be considered a Brady violation, and that would be an unfixable error, possibly. That would be up to the judge to decide, but that is basically what Brady means. Now, if you want to understand really deep lore of the law, the sort of, Lion, the Witch, and the Wardrobe, don't speak to me of the old magic kind of thing, I would recommend Uncivil Law. He is very, very knowledgeable and can kind of break things down in a way I can't, because I am not a lawful law lawyer. But there you go. So that's the first motion. And then we move on to, the amended motion to appoint a forensic psychologist. Now, do we have therapy for this forensic psychologist after she has to examine the brain of Sarah Boone? Because I have a feeling you would need like a mental vomit session. You just need to go into one of those rooms created to smash things, and you just have to Hulk smash things until, your blood pressure comes down. Now comes the defendant by and through undersigned attorney and moves this honorable court to appointment of due process provider to aid in the preparation of the defense in the above styled cause, and grounds would show: 1, the defendant is charged with second-degree murder and has been previously found indigent. 2, undersigned counsel has agreed to accept this case pro bono and requests the assistance of a forensic psychologist to aid in the defense in this matter. 3, the defendant is financially unable to hire a due process provider, in parentheses, the forensic psychologist, to aid in the preparation of her defense, and therefore requires assistance from the court to ensure the protection of her right to due process and effective assistance of counsel. 4, the defense requests that the court appoint Dr. Julie Harper, a forensic psychologist, for the defendant. Now, Julie Harper is not someone new to the Sarah Boone case. It was mentioned in the 15-page motion from the judge when he basically told Sarah, you are SOL and you are pro se. And I will be covering that. Like I said, the start of the school year and kind of fall coming, everything's been a little bit different, but I am working on getting, much more timely with my releases. Let's see, Dr. Harper is requesting and has been paid in other court-appointed cases a rate of $200 per hour to perform her duties, including time spent traveling. Ma'am, I would charge more than $200, but you are kind of like, doing this to help the state or help Sarah. So I don't know. Again, this is such a hard thing for me because part of me, the principled part, knows that she needs a valid trial. She needs to have all her rights, respected and observed. And the other part of me is like, she is such a corroded dumpster water person that I don't care. But I know that the single time I allow myself to not care, that is when I start, wanting to take away rights from everyone else. So I'm having a real hard time remaining principled. Now, the undersigned request, Dr. Julie Harper be appointed at the rate of $200 per hour for work and travel time with an initial cap of $7,500, exclusive of necessary costs allowed by the statute. In addition, reasonable coverage for travel and travel-related expenses would be capped at $2,500. So there you go. A cool $10,000 to mentally check out Sarah Boone. To be fair, I would pay that, but I want the report to come to me. I'm like, what is wrong with this chick? 7, in court on September 3rd, 2024, the state indicated that it takes no position regarding the defendant's request. 8, counsel for the defendant requests that the court grant this motion nunc pro tunc to August 30, 2024, the date he filed the notice of his appearance herein. 9, this motion is made in good faith and for no other reason. Well, I think we all want to understand what is wrong with Sarah Boone's head, but I am sure the taxpayers are super-de-duper happy that they're paying another $10K possibly. And then we have this. I mean, it has been a commotion over in the Sarah Boone area. I am surprised there are not ripples through the ocean with all of these motions going in. Amended motion to appoint a crime scene reconstructionist and death investigator. I only see this going badly for Sarah. Again, this is not in dispute. I wish that this attorney would be urging her to go with a plea deal. I really do. And I say that in full knowledge that I give Sarah a hard time. I do, because I think she has displayed inhuman behavior to the nth degree. But I do have a small part of me, I try to squash it every day with my dark humor, that believes that everyone is capable of a redemption. But I wish she would just humbly say, I did something wrong. I didn't intend for it. It was unintentional, but I did cost a family their entire, their future. Yes, George was struggling, but taking away that future where things could have gotten better is so beyond painful, because there is not a resolution to some of the things that may have been going on in his life. And I just wish she would humble herself. That's all I think that I would really want. And again, she doesn't have to do this for me, but I wish she would see the bigger picture and do this for George's family. I know she won't. I know she is suffering from cranial rectitis to the point where, like Lemmy Winks, her head is just going to have to come out of her mouth. She is so far up there. Let's see here. The defendant, comes now the defendant by and through undersigned attorney and moves this honorable court to the appointment of due process provider to aid in the preparation of the defense in the above styled cause, as grounds would show. 1, The defendant is charged with second-degree murder and has previously been found indigent. 2, undersigned counsel has agreed to accept this case pro bono and request the assistance of a crime scene investigator. Reconstructionist and death investigator. I switched those around, sorry. To assist in the defense. The defendant is financially unable to hire a due process provider, crime scene reconstructionist / death investigator to aid in the preparation of this defense, and therefore requires the assistance of the court to ensure the protection of her right to due process and effective assistance of counsel. The defense requests the court appoint Dr. Michael Berkland, a crime scene reconstructionist / death investigator for the defendant. Dr. Michael Berkland is requesting and has been paid in other court-appointed cases a rate of $200 per hour to perform his duties. The undersigned requests that Dr. Berkland be appointed at the rate of $200 per hour for 50 hours of work, with an initial cap of $10,000, as exclusive of necessary costs allowed by the statute. In addition, reasonable cover for travel and travel-related expenses capped at $2,500. So here is another $12.5K that we are potentially paying. Now, these are caps. He might not use all of this time, but again, the inconsideration for other people that work hard, the disregard of all of the money that has been spent currently trying to protect her rights is grating. And I think Sarah is not reading the room. I think people who have covered this case are not happy. She is not optically going to come out of this looking any better if they use this battered spouse defense. I am telling you that she is going to probably irritate the entire jury, and the defense is going to, once you see the video, it is all done. It is all done. It is the same thing like when Jennifer Crumbly on the stand said she was a victim. No matter what she said afterwards, no matter how her lawyer tried to, church that up, that was the point at which she probably lost that case. And I think Sarah is going to have an even bigger, more recklessly not self-aware moment where she reveals her true face. Now, the court on September 3rd, 2024, the state indicated that it took no position regarding the defendant's request. 8, the counsel for the defense requests the court grant this motion, nunc pro tunc, to August 20th, 2024, the date he filed this notice to appear herein. 9, the motion is made in good faith and for no other reason. Wherefore, the defense respectfully request that the court, and they didn't change the name, it's copy and paste and then you insert. I at least know this about computers, but they continued to put Julie Harper from the other one, but this is in fact for Michael Berkland. And our final motion in this ocean is a motion to appoint a clinical psychologist. Yes, we would all like this report, please, ma'am. Please CC us in on this report. We would like to know what the hell is wrong with Sarah too. Thank you and so much. Comes now the defendant by and through, blah, 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 blah. Let's get through this. Defendant is charged with murder in the second degree. She's pro bono. She's indigent. So basically, the defendant is financially unable to hire a due process provider, a clinical psychologist. Now, they are going to appoint Michael Brennan, a clinical psychologist for the defendant. Now, he is going to get paid $200, an hour with a cap of up to $7,500 and, travel to cost up to $2,500. And I begrudge none of these court-appointed experts for getting paid. That's not my issue here. My issue here is that so many resources have been expended on a woman who is acting like a toddler. And that's where my frustration comes. I want her to have her day in court with all the I's dotted and T's crossed so that Jorge might get the justice that he can on this earth. Again, it is morally reprehensible to me that she's not cried a single tear, but she's shown more passion, more anger for people basically disrespecting her super Karen-ness. So there you are. He did file a lot of motions. I expected these motions because this is the formal way that you ask for funding. But it is a motion explosion up in here. And don't forget, tonight on the 19th, I will be doing a very special, one of those after school special sort of, screenings of Sarah's hearing today, since I sort of forgot. I am a chaos coordinator and I wish I could coordinate my own chaos, but I bought a planner, so I intend to use it. So, cheers to not being a hot mess express. And I would recommend an adult emotional support beverage for this hearing. I will be indulging, and I think that's the only way that one can deal with Sarah. Unfortunately, any whoozle, be kind to yourself, be kind to others. And you know what? If people don't like you, screw them. Just live your life and be you. Don't expend energy on negativity. And I will see you guys back here at 6 p.m. Eastern, not daylight time because we forgot that, Eastern time. So I welcome you to come by or join the replay club. If you like this video, please push the like button. Please subscribe. Please do all of the YouTubey things. Thank you so much. And I will see you guys in a bit. Bye, guys.